Okay. Hello, everyone.
Hello, everyone. Welcome to our fourth lecture in our course Competition Policy and Strategy, um, which is the English translation of the German lecture Wettbewerbspolitik und Strategie that I gave in 2020. Today we're going to talk about competition policy. So what we're basically going to do is to discuss certain basic concepts that we have to know when we talk about competition policy. This is fundamental to understanding how the legal framework is designed in most countries in the world, and we will also tie that to what we've already learned in the previous three lectures, so that we have a basic understanding of why these policy goals and policy rules are as they are, right? Even though we're going to dig into that in much more detail in the upcoming lectures. So before we jump into the topics, please make sure to like the video and subscribe to our channel. This would support us very much, and we would appreciate it. Okay, so competition policy. What is competition policy? Well, the goal of competition policy is to secure that that competition in the economy is functioning properly, right? That basically means, we've already learned that, we should prevent situations where competition is so impeded that we move towards a monopoly setting, right? So again, recall the concept of that line where we have one extreme that is perfect competition and the other extreme that is monopoly. And also recall that I've told you that it's basically both things are kind of like benchmarks in a sense, right? So it's rarely the case that a market is perfectly competitive, and it's also rarely the case that a market is really monopolistic, right? The reality will, most of the cases, lie between the two extremes, right? And what we want to do is to make sure that we, in this given outcome, that the market is not moving towards the less competitive, but rather more towards the more competitive side, right? And why? Because we have learned that monopoly is basically bad because it leads to inefficiency, right? So allocative inefficiency. However, and that's also something we have to keep in mind, when we talk about impediments to competition, then it could be that we are in a world where a monopoly arises naturally, right? That's what we've talked about in the third lecture, is that basically when the cost function and the cost structure in the market gives rise to a setting that is characterized by very high fixed costs and low marginal costs, or constant marginal cost, we get to a situation where it's better to have a single firm in the market. And that way we can ensure that from a cost perspective, we are producing efficiently, right? And in order to prevent allocative inefficiencies and dynamic inefficiencies, we have to regulate the market, right? So what we want to do, though, is to protect the consumer in all of these situations, right? So it could be that we have markets where we expect monopolies to arise and to be stable and to be efficient. However, we want to regulate them in the sense that we protect consumers. In all the other markets where we could have competition, we want to avoid any impediments to competition that harm the consumers, right? So our goal is always to protect the consumer's interests. And when we talk about competition policy, then we have basically three major areas that we're talking about. And these areas are mergers, cooperations between firms, and abuse of dominance, right? In Europe, we also talk about state aid, which is something that is relevant, of course, but it's not a fundamental thing that we're going to address in this lecture. So basically, note that it is there, but it's not something we will talk about too much. Okay, so let's go through these three major areas. The first area is mergers. And when we talk about mergers, it's basically two firms or more becoming a single entity, right? And this could be horizontal or vertical. What does this mean? Well, horizontal means you're in the same tier of the market, right? So if one car manufacturer merges with another car manufacturer, then you have a horizontal merger, right? If you look at vertical mergers, you have a situation where the firms are not on the same tier of the supply chain, right? So if a car manufacturer merges, for instance, with a car dealer or with a producer of certain inputs like seat belts, for instance, right? Then we have a vertical merger. And it is important to distinguish between the two because horizontal mergers are usually considered more harmful or potentially harmful to consumers than vertical mergers are. And this has particular reasons that we're going to address in more detail in the upcoming lectures. Okay. So, with merger control being one of the central pillars, it's important to know that these are very sophisticated procedures, and these procedures basically take place in the sense that you have, when you merge and you are over certain thresholds, you basically go to an authority and say, well, look, we're going to merge, and they are going to either block or allow the merger. Most mergers are actually not blocked, but that's, again, something we're going to learn in more detail. Next fundamental pillar is cooperation between firms. And what comes to mind immediately, and what is also like basically kind of like the elephant in the room in this lecture, is collusion and cartels. And this is basically so important because over the course of the last, I would say, like 80, 90, 100 years, and probably also before that, well, then it wasn't probably formalized, but firms talking to each other and colluding, thereby harming the consumers, is something that it was always a goal to prevent, right? And that is the theory behind that is something that we were going to talk in very much detail in the upcoming lectures. So it's going to be a staple of this lecture, if not the most central part to this lecture. Okay, besides collusion and cartels, we have horizontal cooperation and horizontal restraints to competition that are very closely, or the latter are very closely related to collusion and cartels. However, horizontal cooperation could be beneficial in some instances, right? So it could be that firms in the same tier of supply chain cooperate without harming the consumers, right? And this is, for instance, or could, for instance, be the case if you have an R&D corporation, right? So you want to introduce certain innovation, but you can do that only if you cooperate, right? And that can be beneficial to consumers, and it shouldn't be blocked per se, right? And that's something that is dealt with separately, basically, from collusion, if you talk about this from an economic perspective. And besides this horizontal cooperation, we also have vertical cooperation, right? So, and restraints to competition. Vertical cooperation could, for instance, be just two firms on different levels of the supply chains cooperating, again, to promote a certain innovation or something. However, they can also harm competition when we think about, for instance, resale price maintenance, which would be the situation when an upstream firm basically has several downstream firms. So, for instance, you produce a certain good and you deliver it to certain retailers, and you tell these retailers your retail price they have to charge. That would be an example of resale price maintenance, and this can be harmful. It's still among theorists and empiricists, it's still very much of a debate whether this is always harmful or how harmful it is. In reality, we know that, first of all, in the EU, resale price maintenance is per se forbidden, so it falls in the domain of what we will learn in the next slides as being something like a core impediment to competition, whereas in the US, they have moved away from this standpoint a little bit, right? And there's also exemptions from this rule. So for instance, if you look at the fixed book price law in Germany, and it's not only there in Germany, it's also present in other states such as France and even Japan. In Japan. And the thing is that what you have there is basically a resale price maintenance, which is introduced by law, right? And that's an exemption from basically our competition rules, right? And it's still very much subject to discussion whether this is good or bad, right? Okay, so the final pillar of competition policy is abuse of dominance, right? So if you have a firm that is, due to its market position has the opportunity to abuse its power, its dominant market position, then this is not good, right? And it can do so, for instance, by blocking entry or deterring entry, and it can do so through various ways, right? And one example would be, again, I'm not evaluating anything, I'm just describing. There is this case of the Google case in the European Commission, where the European Commission over the last few years has run several investigations and has fined Google several times for abusing a dominant market position, right? And the fines are pretty significant over time, and we have a video on that on Economics to Go. And the thing is that basically what the European Commission states is Google is doing, and it's not only the European Commission, it's also in the US very present, that through various means they basically corroborate their dominant market position by deterring entry, right? Or disadvantaging competitors. Okay, so how does this enforcement procedure in competition policy actually look like? Well, first of all, if you look at a national level, for instance, in Germany, you have what we call a federal cartel office in Germany, and every European country has such a cartel authority, and basically every country, as far as I know, basically every country should have something like that, at least every industrialized country. And in the EU, we also have on top of that DG Comp, which is part of the European Commission, and this authority is basically responsible to prosecute infringements, or basically execute competition laws on EU level, right? And whether it's Bundeskartellamt is responsible or European Commission basically depends on whether this given competition policy issue is only of national importance or has EU-wide importance, right? And if you look at the US, you have the Federal Trade Commission and the United States Department of Justice, DOJ, and FTC, which are responsible. And these two responsibilities have also something to do with a fundamental difference in how certain infringements are treated in the two legislations. Okay, so if we look at the EU in more detail, right? If we are talking about a European Union competition policy, then we start at the highest level, which is basically the European Commission. And there, if we look at the EU, we have a primary legislation, which is for us most important are Articles 101, 102, and 107 of the Treaty for the functioning of the European Union. And Article 101 basically deals with collusion, so cooperation between firms in the sense that they agree to set a certain market price collusion, or allocate market shares, whatever. That's part of Article 101. Article 102 deals with abuse of dominance, and Article 107 is considered with state aid. Right, so here we have our three three pillars again, uh, 3 or 4 pillars again, and merger control is something which is dealt with in separate legislations. Okay, the secondary legislations of the EU are also important. So there we have regulations, in German Verordnungen, and they must be adopted by member states, and merger control would be one of these regulations that basically regulates how member states have to deal with certain issues. Then we have directives, which are called in German Richtlinien, and they lay out goals, and to achieve these goals, member states have some leeway, right? And the last thing that we have to know is that there's also decisions, Beschlüsse in German, and these decisions can address member states or firms, right? So, example would be a firm infringes competition law by colluding, and then there is European Commission, DG Comp, which releases a decision that addresses this particular firm and fines this firm for the infringement. That would be a decision, right? Very important in terms of competition policy applications. Okay, so if we look at Germany, we have what we call Gesetz gegen Wettbewerbsbeschränkung, GWB, and basically we have three important areas here. So paragraph 1 is dealing with collusion, basically very similar to 101 of the Treaty for the Function of the European Union. Then we have 18 to 21, which deal with abuse of dominance, and paragraphs 35 to 43, which deal with merger control, right? And what is also important to note with respect to Germany is that there are 2 other institutions which are very important when we talk about competition policy and basically IO in general. And these are the Bundesnetzagentur, the Federal Network Agency, and the Monopolies Commission, Monopolkommission. And these 2 agencies and institutions have different tasks and priorities, right? So the Federal Network Agency is a regulator for network industries such as railway, postal services, and energy, right? So currently, in the energy crisis, over the course of the Ukraine war, the Federal Network Agency is in the media pretty much every day because it monitors the gas consumption and the saving, or basically the amount that the inventory that we have available, the gas that we have available, and projects it over the winter, whether we can, whether it's sufficient to to have enough gas available to fuel the economy and to have enough available to produce energy and heat. Okay, so that is basically a regulating industry agency. So it has a lot of responsibilities and authority. On the other hand, we have the Monopolies Commission, and they are more of an advisory board for the government, right? So they are not responding, even though the name might suggest that they are not regulating monopolies. They are more of a regulatory board. And for instance, they have written some sort of report about whether to abandon the fixed book price system, which we have just talked about. Okay, so now we move to the US, and there we have the Sherman Act, and the Sherman Act has 2 sections. Section 1 deals with collusion, Section 2 deals with abuse of dominance, right? So that's basically the corresponding law to GWB and TFEU, right? And at this point, I think it's very important to note one very crucial difference between the US and the EU, although I'm sure there are a lot more than that. If we look at cartel infringements, and again I said this is a very important part of this course, cartel infringements in the EU are basically prosecuted according to civil law in most of the times, which basically means that if you are speeding on a highway, right, this is treated equally as infringing cartel laws or competition laws and colluding, right? So you get a fine, and you also prone to similar to private litigation, so you can be sued afterwards, but you're not generally not subject to criminal laws such as in the US, right? So in the US, if you violate competition laws and you collude with your rivals, if you collude with your rivals, not every violation of competition laws, but if you collude with your rivals, you could go to jail, right? That's possible. So that's a fundamental difference between the EU and the US. Okay, so the last thing that we're going to talk about in the context of competition policy is first something like the objective function, right? So what are we trying to do or to achieve when we talk about competition policy? What is the goal, right? So I've just told you that basically the consumers are the most important thing, but there's a discussion whether we should maximize total welfare. We know total welfare involves profits and consumer surplus, or whether we should only talk about consumers, right? Consumer welfare standard, which would mean that we maximize consumer surplus, irrespective of what happens to the producers, right? And the total welfare standard has some advantages, as it also involves productive and dynamic efficiencies that could lead to lower costs and not immediately or directly influence prices. And innovation is sometimes hard to assess, but it could be a part of total welfare standard, right? And in this case, we basically have in mind the idea that consumers are shareholders of the firms, right? So if we apply total welfare standard, and we have a slight reduction in consumer surplus, but a strong increase in firm profits, we would say that, okay, the certain measure that we're talking about here, for instance, a merger, would be okay, as the consumers are considered shareholders of the firms, and as they realize higher profits, a small loss in consumer surplus might be compensated for. However, if we follow a consumer welfare standard and we see, okay, the consumer surplus decreases by a tiny bit, even though the total welfare might increase tremendously due to industry profits rising and overcompensating this small loss, we would say, well, the certain measure, for instance, a merger, would be blocked, right? And the idea behind this is that consumers face high costs when they want to defend their interests, right? So for producers, it's pretty easy, right? So I have a market, and there's probably like 5-6 firms being active in that market, and on the consumer side we have probably 100-200 million, sorry, that's a little bit too much, but say we have like 2 or 3 million consumers of a certain good, and they have purchased, like, think of my olive oil example again, right? So if there's a cartel of olive oil producers, and we say we have 6 large olive oil producers in an economy, and every individual buys 1 bottle of olive oil a year, and we have like 80 million inhabitants in the economy, then we would have 80 million consumers having bought a single bottle of olive oil a year, and they would have to defend their interest in the sense that they would have to kind of formulate what they want and probably reclaim damages or something from those 6 producers. And it's very hard for them to coordinate in a sense, right? So it's very hard for consumers to defend their interests, whereas it's relatively easy for firms, right? So they can do lobbying and things like that. So that would be an argument in favor of a consumer welfare standard. And usually in Germany, we follow this consumer welfare standard. It's basically a guideline, right? So if we have a merger and the consumers are harmed by the merger, there's pretty much nothing that's or very little that speaks against this, then we block a merger, right? And that is because consumer welfare is our guidance, basically, and our objective is to maximize it, right? Okay, lastly, we talk about per se rules and the rule of reason. A per se rule means that in in our case, anti-competitive practice, is simply prohibited, right? And that basically applies, for instance, to cartels, right? Hardcore cartels. There is, of course, and we will talk about this in more detail in the upcoming lectures, there is, of course, 101.3 that says that if a certain cooperation is helps the consumers, then it might be it might not fall under per se prohibition. However, if we have a hardcore cartel, at least I am not aware of any instances where this actually applies, right? So that's basically just a per se infringement. And you can also think in a broader scheme, murder is basically the same thing, right? So it's pretty hard. I mean, there's basically no instance where murder is not per se forbidden, right? So that's basically comparable. And before we talk about the pros and cons of per se rules, we should shortly talk about rule of reason. And the rule of reason, in contrast to per se rule, is just saying that we have a case-by-case evaluation of a certain thing, right? And a good example would be mergers, right? So it would be kind of like a little bit naive to say that every merger is bad and thereby we block mergers altogether, right? And what we instead do is to look at every merger and say whether it's good or bad, right? Of course, in practice, we have some thresholds below which, for instance, when it comes to the annual revenues of the firms wanting to merge, then we say that's not a problem, right? But when we have two large firms wanting to merge, there will be this will be basically under the competition authorities will basically investigate this merger and evaluate whether it is by case investigation, whether it is beneficial in the sense that is effective competition or are consumers harmed, right? And if we compare these two rules, then we see that per se rules have advantages in the sense that they are quite efficient and it's low uncertainty, right? Because if you know that, for instance, cartel infringements are per se forbidden, then it's pretty efficient. That enforcement can be pretty efficient, right? Because if there is collusion between firms, then there's going to be fines. There's basically a little leeway here, right? And there's also low uncertainty from the viewpoint of the firms because it says, okay, probably the fines are, there's uncertainty about fines and there's, of course, uncertainty about whether being caught or not. However, there's no uncertainty whether this certain practice is illegal or not because it's per se forbidden, right? The rule of reason basically does not have these advantages, right? Because it's a higher uncertainty and it's of course more costly than per se rule, right? So if you were not only to investigate every merger, but also every cartel infringement, that would be even more costly, right? So that's pro of per se and a con of a rule of reason approach, right? However, a per se rule has the danger of us banning efficiency enhancing practices, right? And an example that I would like to bring forward here is again the resale price maintenance, right? Because if we always ban it, and there may be instances where it is efficiency enhancing, then it's probably not so smart to have it as a per se rule. And we see if we compare the German and the US approach, especially when it comes to resale price maintenance, there is a difference here, right? And that's, it's debatable whether this should be per se forbidden or whether we should apply the rule of reason approach, right? And there's also the thing of safe harbor here, right? Because if we always say, okay, you are not allowed to collude, but every firm with a revenue of below 1 million can do so, right? Because it's too unimportant for us to consider it, right? And I think all of us have at some point encountered situations where a local tavern, you know, tavern owner goes to another tavern owner and says, "Look, the price of beer at my tavern is €5, and you charge €3. So let's move together and say we probably both charge a price of $4.50 or something, right?" And that is probably something that, as a competition economist, we know that this is basically just collusion, but it's safe harbor because they are too small, right? And if you have per se rules like that, well, you create such safe harbors, right? And the upside of rule of reason approach is, of course, that we have a lower risk of making these mistakes, such as risk of banning an efficiency enhancing practice, such as resale price maintenance, which in some instances may be beneficial. We just don't know. We should have to look at this, right? So when we assume that a rule of reason based approach is more optimal, it's something, again, that's subject to debate, right? Okay, so this is basically all I wanted to tell you when it comes to the basics of competition policy. We are going to use these concepts and to solidify these concepts in the upcoming lectures where we apply these things in more detail, right? So we're going to talk about mergers, we're going to talk about cartels, and we're going to talk about abuse of dominance. And now we know how it's basically treated when it comes to a competition policy and a legal perspective, right? So that's important to know. Okay, so that's it from my side. Thank you, of course, for your attention. Please like the video and subscribe to our channel. We see you in the next video.